Okay, I don't think anybody is in the chat yet. This is, for the replay crew, this is Sarah Boone's hearing, hey CB, that I thought wasn't going to be broadcast until this afternoon for some reason. I think because they did that before. So I thought I had all day. But here it is. So we're just waiting for everything to get started. I'm going to say hello to everybody and talk to the chat until it gets started. But then I'm not going to be chatting a whole lot while the hearing's going on. We'll watch, I'll stop and make comments, and then I'll chat back and forth with everybody at the end. And that seems to work better for people who don't make the live stream but still want to see the hearing and the commentary. Hello, Ola and Detective. It's nice to see everybody. So we're just waiting, and my watch died, so I don't know how long they're going to take. Let me know if the sound is okay, because sometimes there's a big difference between what's coming from the court and what's coming from my mic. Good morning, Edmonton. Hello, UK. Greetings from Canada. Yes, Joyce, we get to see the new lawyer. They still don't have sound yet here. Hi, Anna Banana. Thank you. Hello, Australia. Thanks, Captain KD. We'll see what, sometimes the court sound is good and sometimes it isn't. So we'll see. Judge Kranick has 28 cases on his docket today. That's doable if everybody has a lawyer, right? It depends. We got blasted there.
Oh. Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience.
How's this sound for you guys?
Thanks.
Hey, Brantford. I didn't know you were from Brantford, Anna. Yeah. Sound is awful. Okay. It might get better. Sometimes it does. A little loud? Okay, I'm going to try turn it down. Is that better? Yeah, Mal is saying everybody's microphones are different. And then there's the ambient sound too, right? Good morning, Jane. Hi, Estonia. Well, hello. The new lawyer is Owens. Erin says she'd rather be too loud than too quiet. Yeah. Thank you, Amy. Someone in the comments said, in reference to this lawyer, last chance to run, dude. I think he doesn't want to run. We'll see what happens. Apparently, he was a public defender, like the head guy, elected. And he's been practicing a long time. Hey, what's going on? So maybe he thinks he can handle her. What is happening? Truth 17, John 17. Why is he doing this? What's in it for him? I don't know. Maybe he believes in it. There's so many reasons why somebody might want to do that. Tracy is here, says, I wonder if Sarah is loving this fame. Yeah, I'm sure she is. It's amazing how much she has been given, and yet she doesn't seem so grateful. They're still waiting for this date, Monique said. I feel like I should be entertaining you while we while we wait. I'm not good at that. Um, I don't remember saying that, Jay, about George crying. Futuristically, futuristically, what a name. Says there'll be 14 lawyers by the time we're done. Jay, you're okay. So Jay's saying that he's been saying, he or she has been saying this is a great way for a lawyer to make a name for themselves. This guy apparently doesn't need to make a name for himself. He's already known. And I think he's doing this pro se. Or, sorry, pro bono. Duh. I want the judge, though, to say to this lawyer, like, look, if you're taking this, you can't get off. You can't get, you can't leave no matter what. Somebody, Grace is saying, well, is he keen? Well, I think you'd have to be to volunteer for this. Captain KD, well, then he can make the October 7th date. I think his JG, there is no sound yet. I think his issue is not so much himself preparing, but filing deadlines. Futuristically is saying, yeah, a lot of people are fans of Boone. Yeah, I've never understood that. At the very beginning, when I first saw this story, I thought, how horrible, because I heard this story about they were playing a game and then what happened. And I thought, how horrible. But then I watched the body cam and thought, she is more interested in herself. And this is clearly not what happened. What she's saying is not what happened. Captain KD says, I'm sure he was urged by the other YouTube lawyer. I have no idea. I'm not going to say people did things when really I have no clue. Jay is asking, is Sarah going to try and hug her lawyer? I don't know. Bonnie, hi from Muskoka. Is this Muskoka, Ontario, Bonnie? If that's the case, it's beautiful up there. Yes, Mala, there are fans of all kinds of criminals. Sometimes in court, we would be amazed by who shows up to be on the side of the defendant, even after he's done horrible things. Watson just opened a door. Crikey, that's going to be a problem. That door was shut. Hey, puppy. I don't want Watson to start like barking out the window or something while we're doing this. I still do not believe that Mr. Torres got into that suitcase under his own steam. And the reason I don't believe that is because of the silence all of a sudden in the middle of a huge fight. So it's not like they're having a huge fight and he says, oh, I think I'll get in this suitcase. Or, oh, gee, do you want to play hide and seek? No. I think the whole hide and seek story is in people's heads. So they're trying to incorporate that into their theory of what happened. But I don't think there was hide and seek at all. It's just my opinion. Hello, Connecticut. Monique says she kind of backtracks during the interrogation and says they were playing tag or something. Yeah, she was modifying her story to fit with whatever she was faced with. And this happens when people lie. They realize there's a piece they need to fill in. And so they find something to fill it in with. If you get a chance, I mean, it's kind of hard to watch, but I did a whole series on Jennifer Pan. I think the playlist is called The Pan Family Horror, and how this seemingly sweet, innocent girl, who everybody thought was the victim at first, actually, they all didn't think that. Anyway, she lied and lied and lied, and you see her adjusting her story through the whole interrogation. GC, you're saying that you think they were drunk and someone said, I bet you can't fit in there. But we know that's not what happened because of witness statements. They were in the middle of a huge knockdown, drag-out fight, a more extreme fight than they'd ever had. There was screaming and then a sudden silence. And then the crashing down the stairs of the suitcase. So in the middle of this big fight, they didn't just stop and say, we're playing hide and seek or truth or dare or whatever. Oh, Captain KD is saying that you lived in Markham at the time of the pan crime. Yeah, that was a heck of a story. I think a lot of people were surprised by it. True 17 John 17 says no. George's brother said he was not drunk that night. That's correct. I'd forgotten about that. It was Sarah yelling at him that night on the phone. Oh, you liked that series, Pan? Nope, not today. Thank you. CB, the Pan story is crazy. Yeah, I didn't think a lot of people would know about that, especially considering most of my audience are American. So if you live outside of Canada, you might not have heard about that. I this that's the other thing somebody's talking about Sarah dragging out the case. I don't know. I don't
Qualify for
know.
representation by the Public Defender's Office in this matter. Can I get appearances, please?
Yes, Judge. Samantha Smith, and at this time will enter plea of not guilty, waive reading of the charges, and reserve the right to file anything.
Okay. All right, sir, I'm going to give you 2 dates. You don't need to memorize these. You'll be given paperwork momentarily. The first date is the date of your pretrial conference. That's where we're going to discuss whether or not your case is ready to proceed to trial. That'll take place on November 22nd at 1:30 in the afternoon. And if your case is ready to proceed to trial, it may be tried during the 2-week trial period beginning December 9th at 9 a.m. Before you leave here today, make
I
sure
think
you
they're
give all your
addressing
contacts
someone
and
else.
communication information to your attorney to your right, and I wish you the best of luck, sir.
Mally, you did hear the Pan case. Tube Rafter, what time does this get rolling? I expected it to be rolling now. So I don't know. I'm hoping that that people can be entertained enough by the chat. Yeah, someone's pointing out that Sarah said she remembered leaving an opening in the suitcase, but not the event or recording the event. Look, we get it all the time where offenders will say, "Oh, I don't remember. I'm not guilty because I blacked out. I don't remember." Not remembering doesn't mean you didn't do it. Doesn't mean you couldn't form intent at the time. And if you don't remember, it's pretty hard to come up with anything to defend yourself because you don't remember. Froggy's saying that Sarah in her brain thinks it's an accident and she's innocent. I think to some extent, well, I guess with the way Sarah thinks, that's probably accurate. I think if in her brain she's thinking, well, I didn't intend to kill him, I just intended to torture him, it's all good. So she disregards the rest of it. She treated him like a thing. Futuristically, I also think she knocked him out and then put him in the case. Dr. Barry, hi, nice to see you. Says people with narcissistic traits often see others as objects. And by the way, chat, if you don't know Dr. Barry, she has a channel, and I like her channel. I recommend it. It's nice to have you in the chat, Dr. Barry, because there are things that I don't know that you do. That's helpful. Dr. Barry's doing reports in the background. Yeah. Yeah, we could all be doing dishes or something. Wyatt brings up a good point. If you kill a carload of people drunk driving, you didn't mean to do it, but chances are you're going to prison. Exactly. And the other thing with Sarah in this case is she said to the officer on scene, she wanted to make him squirm. So it was clear her intention was to harm him. The minute he says he wants out of that case and she doesn't let him out, that's forcible confinement, man. You can't do that. So she wanted to make him squirm. Her intention was to harm, to torture, to degrade, and that fits that second degree. That's one of the elements, right? Depraved mind. Here she looks a little... Oh, look how she's smiling, eh? She looks almost jubilant, like she's got some great victory, doesn't she? Wow. I don't think I've seen her this happy. She's happy as if something's going well for her, Al Rush says. Yes.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 101077.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed.
Ooh, so the viewing did take place. The viewing of the exhibits and evidence did take place, and the deadline for objections is passed. So if there are no objections to the evidence, like the deadline's passed. So we haven't seen any. Very interesting.
On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Castore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense. That was filed on August 14th. The next day, August 15th, JSC has filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer. But we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these, Judge, yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I push them in?
Yes.
Oh, well, this is interesting. Reappointing the forensic psychologist that dealt with Sarah before makes a lot of sense, right? This person has already met with Sarah a number of times, already built a file, was already prepared for trial. That makes total sense. Abandoning the neuropsychologist makes sense. This crime scene reconstructionist, this is very interesting. I wonder what it is that they are going to allege. I wonder if the hide and seek story is going out the window and it was a good day. I wonder if they are going to allege that they were in a big fight, as the witnesses say. And she is going to somehow sort of work the battered spouse into this. This is interesting.
State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars. They called it September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the portal was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't. They were all filed yesterday, 9/8.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both.
So they can't find the autopsy photos and crime scene photos because why? Because Sarah has it.
With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State, you had the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally in writing, given the lack of time we've had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon.
Spell that out for me, sir.
Dr. Michael Brandon.
B-R-A-N-N-E-N.
Did you see that? He just slides in another one, an additional one.
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marcia Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger.
Okay, this makes me mad. And or those of you who followed me for a while know, I advocate for victims of domestic violence. I advocate for all kinds of victims. Maybe she was fearful. Maybe her perception was that there was a threat to her at some point earlier in the evening. But at the point where he's saying, I can't breathe, and she says, F you, that was not her being afraid. That was her being vengeful. That was her being angry. If she was afraid, and I said this before, afraid to maybe let him out once he was in there, she still could have gone and got help. And she did not. And not only did she fail to go get help for him at that moment, she taunted him and mocked him and filmed it. And intent can be formed very quickly, and it can change very quickly. And this moment where he is dying, begging for his life, saying he can't breathe, that is the moment of the crime. That is the moment where intent also matters. And her intent clearly wasn't, I'm afraid. Her mental state was, I'm angry and I'm gonna get you. So this part of the trial is going to make me mad. I'm sorry. Let's just keep playing it.
In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And?
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Miss Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of the record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other.
He just went through, he's saying he needs more time because this psychologist has to come back out. And in his motion, if you'll recall, he says, well, it takes time to establish trust. And that's true if you're talking to a psychologist you've never talked to before. But he just got finished saying at the beginning of all this, saying, oh, yes, this particular psychologist has met with Sarah a bunch of times. So they don't need all that time to build rapport and all of that. So he's talking out of both sides of his mouth a bit, in my opinion.
Potential forensic psychologist, Dr. Michael Brandon, he's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the two forensic psychologists for them to help formulate their opinion as to whether she is, in fact, the better spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her.
I'm sorry. He spent 3.5 hours with her. How much does that tell you about a person? 3.5 hours. How well do you know someone after 3.5 hours? Even if you're a professional. And we know she lies. And we know that she lies well enough that a lot of people roll with it and believe her. So she spent 3.5 hours, just like she did in the interrogation, telling this lawyer how horrible the victim was and all the horrible things he's done. Now, look back at all of her allegations against her various lawyers. Everybody's horrible and she's wonderful. Well, don't you think she just played the same game with this lawyer? Everybody's horrible and she's wonderful. And Mr. Torres was horrible and she's wonderful. And my understanding is that Mr. Torres was not a saint, and it does appear that there was violence both ways, but we don't know all the story behind it, and we can't rely on what she says. And also, I want to point out, it's really common to blame for the offender, to blame the victim. So then it makes it harder to tease out if something was done in self-defense. And by the way, self-defense and battered spouse are different. So they're not the same thing. Okay, I'll shut up now. We'll keep going.
I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim to. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert.
Oh my gosh. Oh my gosh. All right. He wants a whole trial cycle? Come on. And he's framing this as not as we need more time, blah, blah, blah. He's framing it as we need to be allowed to develop a defense. They were ready to go to trial at the beginning of this. They had their defense set out. They had their psychologist. They had everything that they needed. I hope the judge does not allow this.
To go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, That's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So,
how do you come onto a case so late in the game, knowing the trial, knowing the trial date, knowing that the judge has said there will be no more delays? You come onto a case not prepared to work 15, 16 hours a day, weekends included. You knew you had to be ready, so you can't complain that you can't be ready.
because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for me.
So in order to go with this defense, the defense has to file their intention to go with this defense. But the prosecution just stood up and said, yeah, we already know. We already know they're going for this. And by the way, we have our own expert. So there's a way around this. Let's see if they do it. And if you're ahead, please no spoilers in the chat.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome.
The judge comes back with this logic. Well, the reason it's only 30 days notice is because it only takes 30 days. Therefore, buddy, you don't need a continuance for a whole trial cycle. And now the defense lawyer is arguing a point that is not the point that the judge was making. So he's arguing something completely different. That's hilarious.
If you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim, I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
All right, thank you. State anything else?
No.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' bases for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. The You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton v. State, 220 Southern 3rd 1152 and 1176, and Bargo v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JACS is not here and have the opportunity to review those. In Ramos v. State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, is established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 Southern 3rd 185 at pinpoint 189, 4 2nd DCA 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pre-trial
Didn't you feel like that was a score at a hockey game? No continuance. Good for him. And I like how he set out all the reasons. And the one part that really caught me is the point at which he said that Sarah Boone has only herself to blame for the withdrawal of 4 of those lawyers. And that remark by the judge, I know, will hit her. It will hit her hard because she cannot take blame for anything. It has to be somebody else's fault. I wonder if we're going to get any more letters or if this lawyer has really kind of taken charge here with her. He's seeing her a lot and talking to her a lot. So he may be able to sort of keep the lid on it, so to speak.
6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form work, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened.
I don't remember that in the order. I thought the state was going to review the physical evidence and that she had the digital evidence. Interesting.
I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. When I went to the jail yesterday, I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence, the defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to...
They just got away with something here. So the time for objections to this evidence has expired. And he just got it handed back to the defense. I wish the prosecution, I guess they're trying to be fair or more than fair.
admit into evidence and tender any objections.
Well, I've got to go by a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State.
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
You know they're going to object to things now.
State, anything else?
Not at this time, Your Honor.
Madam Clerk's going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, by judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court, you'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
I think that's done. She's so happy. Okay, I'm going to address the chat. Battered spout syndrome, my butt. Somebody says we'll have to see what the experts say. I suspect that not all of them are going to agree. How many of you feel like the prosecution isn't really pushing all that hard? Right? They just got away with something here, I feel like. So, I don't know. We'll have to see if
to about February of 20.
We'll have to see if the prosecution gets more aggressive during trial. Will you do this over with your commentary added? I did make my commentary through this. I'm not, do you know, I don't have another 12 hours to do that. So no, my commentary did happen through this. I didn't have a lot to say. Prosecution wants this trial to move forward, Blackbird says. Yes, Watson is awesome. Sharon says, Florida taxpayers stand up. Well, the judge did not allow the continuance. So I think that's good. What did they get away with? Somebody's asking. The court ordered that here's a deadline. So here's when the prosecution has to give this evidence or this discovery by, it's going to be reviewed. And if there are any objections to any of this digital evidence being brought in, then you have to make those objections. And you have to make those objections by, I forget the date, it was August. And once that date has expired, if basically it should have been, well, if you get a new lawyer or you change your mind or something and decide, well, maybe this should have been objected about, well, it's too late. That time period has expired. You were given a deadline and didn't meet it. Well, that time period came and went. So Sarah did not make any objection to any of the evidence coming in, but now this lawyer coming on is saying, oh, wait, I want to review it because I might want to make objections. I wish the judge had said, too bad, so sad, the deadline has passed. But no, he's extended that deadline. So now they have all the way to September 26th so that if there are any objections, they can bring them up at the pretrial. And so that's what I think they kind of got away with, or they got handed a gift there. And what do you want to bet that this defense lawyer is going to object to some things coming in, and he's going to have reasons why. I think we have a real trial coming. But the judge didn't shut them down. That's the point. A commenter is saying, yes, Owens knew what he was getting into. Sure. But you know what? He's going to argue as much as he can. He's going to advocate vigorously, right? Yes, I can't afford StreamYard and the learning curve. Yeah, I'm not even going to address that. Aaron says, Owens can object to whatever he wants. I don't think he's going to get anything excluded. Who knows? We don't know what. We might not be aware of everything that is in evidence. So maybe he will. He might find grounds. Who knows? He can, yes, much endeavors, he still can refuse the objections. But what I'm saying is they get another kick at the can, and they keep getting kicks at the can. Jay says Sarah smiled like she was winning an Oscar. Yeah, really. Just my thought at the beginning was jubilant. So, well, true crime boozer. In trifling matters, Kranick will be flexible. This will undermine her appeal. Yeah, maybe. I think the issue of excluding evidence is a big issue. I think it is. Oh, Buttercup points out that in Sarah's interview with detectives, Sarah said nothing about being scared. So, but she also said, we were having a good day. She was emphatic. And the fact that she was so emphatic tells you that it was the opposite, probably, right? That she's trying so hard to convince them we were having a good day. It was a good day. That, that's an issue that they weren't. But she can come into court, even after lying her face off, right? Come into court and say, well, I was scared of him, and so this is what I did, and who knows what the story's going to be, and scared of telling the police the truth. But you see, I could take this apart in about 10 seconds. She had no problem calling the police over and over and over whenever she felt like it. She had no problem arguing with police, pushing back, even when she was the one at risk from police, right? So it's not like she has this great fear of them or of the system. She used it to her advantage. And we saw the longer this goes on, the more of her behavior gets displayed. So, people could have been fooled, maybe, if she had gone to trial right away, because there would have been no time for her to display who she is. And I don't know. Oh, Shiloh says, well, she just went to bed. If she was so afraid, she just went to bed. I kind of wonder when he passed. I don't know if she knew or not already. So, yeah. DB is saying scared of a dying man in a suitcase. Nonsense. Well, in a real case where there is fear, I could imagine being afraid to let him out. The issue then becomes, well, you could have done something. She could have called police. Like, she's never had a problem before. But she didn't go get help from neighbors or anybody else. John says she told her neighbors that if they ever heard loud noises, not to bother with it. That can go both ways. Sometimes a victim will say that. Victims say that. Don't call the police. So you could argue that either way. And when she went upstairs and called Brian, did he answer? Yes, he answered. He told investigators that he doesn't remember what the conversation was about, that she does that sort of thing, so he pretty much ignored her. Yes, and Acquired Taste is talking about this, hearing the suitcase going down the stairs in silence. That's reversed. There was the silence. And this is what's so key. The knockdown, drag out, fight. Then silence. Then the suitcase went down the stairs. So the suitcase wasn't downstairs being, ready for donations or something. It was upstairs, right? The fight, something happened to cause that silence. And then he was in the suitcase, crashing down the stairs. And then the videotape, or I keep saying videotape, I show my age, the video recording, you can see they are downstairs. So that suitcase is already downstairs at that point. Elle says Brian also said she hit and clawed him too. Yes. Yes. And the suitcase being upside down, well, she flipped it because it was on video, it was in different positions. So she was flipping it around. So you can't tell me she wasn't strong enough. I mean, obviously she did that, right? Sarah and her lawyer are convinced that there's more than one video on her phone. That's why she keeps insisting on seeing her phone. This is what a commenter is saying. I think that, and we've talked about this before, there are photographs and notes and such on her phone where she documented what Mr. Torres did to her. The thing is, she has these photos and we have her side of the story, and that's it. We don't have his side of the story. He can't talk to anybody. Oh, the pretend judge is in the chat. That name is hilarious. The evidence hearing did not happen, pretend judge, but there was no continuance granted. So I think we are pretty... Oh, Teresa's saying George broke a TV. Yeah. This trial is going to be interesting. And I think with this lawyer, we're going to have a real trial. And I think that's a good thing. And I think it will be interesting. Domestic violence, oh, I hope I don't get demonetized for this, is a big issue. And it can get complicated. It can get hard to tease out who is the primary aggressor. So, and then add to that abusers blame victims and make the victims sound like crazy, like the victim's crazy. So it's always a challenge. Okay, I think I should end the chat. Thank you for watching with me. It was fun. And trust your gut. I'll see you in the comments.